Things are heating up with the Renters' Rights Bill. It's nearing the end of its passage through the House of Lords. The government has scheduled its own amendments to the bill, which contained a few surprises. And there's been a lot of fuss already about the withdrawal of pet insurance. But there's more to the amendments than that. They make changes to the rent and advance rules for existing tenancies, which is great news for landlords and letting agents managing the transition. There's also potential changes to when rent increases will come into effect. Certain student accommodation will be taken outside of the Renters' Rights Bill altogether. And as they're government amendments, they'll get onto the bill. And they're important as the House of Lords report stage is the second to last time that there'll be an extended debate about the detail of the Renters' Rights Bill before it becomes law. In this video, I go through the key government amendments and explain what they mean for letting agents and landlords. And stick around to the end as I'll then explain the latest on what I think will happen next, and what it all means, and crucially, when is it going to come into force? Who am I? I'm Suzanne Smith, lawyer turned landlord, and I run the independent landlord.com website and this YouTube channel to bring reliable, balanced content to everyone in the private rented sector. And you can sign up for my free weekly newsletter at theindependentlandlord.com/subscribe. Right, let's get started. And I'm going to start with rent in advance, as it's a bit of good news for landlords and letting agents. The Renters' Rights Bill stops landlords from putting clauses into tenancy agreements that require rent to be paid in advance, for instance, at 6 monthly intervals, termly, quarterly. But a new government amendment introduces transition arrangements for existing tenancies that were in force on the commencement date. And that's the date when the new tenancy system comes into force. And I'll explain when I think that's going to be later on. So what this means is landlords with existing tenancy agreements, which have rent payable in advance, can continue those until the tenancy ends. And this avoids a lot of hassle for landlords and letting agents because they're not going to be forced to alter their payment schedules for current tenants just because of the new law. So it's going to be a lot less work. However, this is only for the transition. There'll need to be monthly payments for new tenancies when the rules come into force. Tenants will still be able to pay rent voluntarily in advance, but landlords can't make them do that by having a clause in the agreement once this all comes into force. Okay, let's turn to pet insurance. The government amendment has caused a lot of consternation already, with the NRLA slamming it as a dog's dinner and a new blow for landlords. But what's this amendment all about? Well, starting with the Renters Reform Bill and now the Renters Rights Bill, to use the government's words in their own guide to the Renters Rights Bill dated 15th of January 2025, we know that some landlords are concerned about potential damage caused by pets. This is why the Renters' Rights Bill will allow landlords to require insurance covering pet damage. This will provide landlords with reassurance that any damage caused by a pet can be taken care of, and that the responsibility for preventing and resolving damage caused by a pet will fall for the tenant. So, what does the government amendment about pet insurance do? Well, in fact, it removes all references to pet insurance, but without giving anything in return. Now, I personally had concerns about pet insurance, and I set them out in my written evidence to the House of Commons Bill Committee, flashing it up here. So, on the one hand, if tenants took out pet insurance, how could the landlords be sure that they'd actually take out the right policy, or they wouldn't let the policy lapse? And secondly, if a landlord took out pet insurance and charged the tenant, what would it do to the landlord's claims history? Would tenants be less inclined to control the pet? As I put it in my written submission, safe in the knowledge there'll be no adverse consequences for them because it needed to affect their claims history for it to change their behaviour. But either way, Landlords are between a rock and a hard place now with this amendment, as they'll have to accept pets unless they have a good reason to refuse, but they can't ask for a higher deposit to cover the undoubted extra risk. Now, landlords can still charge a pet rent, but the problem with that is that if you're already at the market rent, then that could be challenged on the basis that the tenant is saying that it's above the market rent. I don't know the rationale for taking out pet insurance. Although I had my qualms about it, I still would have asked for it because something would have been better than nothing. But the government hasn't explained why they're taking it out. Getting it into context, a number of my tenants have pets. And the only issue I've had is when they'd moved out, they didn't leave the carpets clean. And there was a pervasive smell of dog. I got the carpets deep cleaned and took it out of the deposit. There was other damage, not dog related, and I was lucky that the deposit more than covered it. But if you have extensive damage to a property, like, for instance, cats scratching up all the carpets, you can easily get through the deposit. I'm going to be interested to hear how the government justifies this and why they think that this is fair. But it's not just pets and rent in advance. There are other amendments as well. So the next change relates to increasing rent via Section 13. Now, I've spoken about this a few times. The Renters' Rights Bill makes it compulsory for a landlord to use the Section 13 statutory process if they want to increase the rent in the future. And they'll need to give the tenant 2 months' notice to increase the rent, which needs to expire on a rent payment date. But if the tenant isn't happy with the increase, they can challenge it at the first tier tribunal, as they can now. So what the Renters' Rights Bill did is change the date that the new rent would come into effect if the tenant challenged the rent at a first tier tribunal. So let's say that a landlord wants to increase the rent by under inflation, 1%, and that the rent is under market. So it's a really fair rent increase. The tenant goes to the tribunal, and because there's bound to be delays in the tribunal, it'll probably take 6 months for the case to be heard, but the new rent won't come into effect until after the case is heard, and then is not going to be backdated to when it should have come into effect had the tenant not gone to the tribunal. And what this means, tenants won't have any risk in challenging a rent increase. In fact, they've only got an upside because the rent can't increase and it will delay it. And so it's definitely foreseeable that there will be more cases in the first tier tribunal if this is brought into effect. So what the government actually does is a kind of hedging their bet strategy. So it gives the Secretary of State, currently Angela Rayner, the power to scrap the wording on when the rent's going to come into effect. And they can pass a regulation saying that the rent increase can be backdated to the original date in the notice, which is 2 months or so from when the notice is served. So it's not amending the default process in the Renters' Rights Bill, but it's going to make it easy for the government to change it in the future by regulation, which means it doesn't have to go back to Parliament and go through as another act of Parliament. It's easier to pass a regulation. The government hasn't explained why they're doing this, just the effect that the regulations can substitute a different date. Maybe they want the option in case the first tier tribunal gets overwhelmed. Spoiler alert, that's going to happen, because why wouldn't people challenge something if it's at the very worst going to delay when the rent increase comes into effect? Right, the next one is on joint tenancies. In the Renters' Rights Bill, tenants can terminate the tenancy at any time with 2 months' notice. And this applies to joint tenancies. So if one tenant terminates, it will terminate for all. And so a joint tenancy is when there's more than one person on the tenancy agreement. So you might have a couple or a group of friends, rather than when people let individually buy the room. The Renters' Rights Bill says that a landlord can waive part of the notice period and have, say, 1 month's notice. So the amendment makes it clear that in the case of joint tenants, all of the tenants need to agree to this. And this will avoid someone already lining up somewhere to go and terminating it immediately, leaving the others in the lurch. So it means that all tenants will have at least 2 months' notice to leave if a fellow joint tenant serves a notice to quit. unless they're all happy and the landlord's happy too for them to leave earlier. And that seems sensible. In a similar vein, if a tenant wants to withdraw a notice to quit, they can with the agreement of the landlord. However, if they're in a joint tenancy, all of the joint tenants will need to withdraw it to stop one being forced to stay if the other wants to stay. And that's another sensible amendment. Right, so now on to student accommodation. It's quite complicated, and as a caveat, it doesn't affect landlords with the standard HMO or flats letting to students. However, the government makes it clear that what we call purpose-built student accommodation, PBSA, is definitely not going to be an assured tenancy, which means it's outside of the Renters' Rights Bill. So what type of student accommodation comes into this category? The amendment refers to a tenancy granted by a person who is pursuing or intends to pursue a course of study provided by an educational institution if the housing provider is either a specified educational institution or if the property is managed by someone who is a member of an approved housing management code of practice. What this means is that if there's a manager or an agent who signs up to an official code, for instance, the ANUK or Unipol codes for student housing. In a LinkedIn post, the leading housing solicitor, David Smith, explained that this meant developments over 15 rooms. And then he added, it also creates a bit of a potential bonanza. There are plenty of operators who are in the student space who are not code members and who may now scramble to join up to gain those exemptions. Given the code is for developments down to 15 beds, it is open to somebody to seek to amalgamate a number of smaller developments and manage these within an approved code, thereby creating the benefit of being outside of the Renters' Rights Bill for some medium-sized landlords. You can see more in his LinkedIn post. But it's worth noting that the Secretary of State has the power to specify particular types of accommodation or managers that qualify or disqualify for the student exemption. So that means they can change the goalposts if they want to afterwards, without having to go back to Parliament for another Act of Parliament. So this means that there is a two-track system for letting to students, one, the big players, and two, the average private landlord. And I think it is unfair to have a two-track rental market. But I don't think the government's going to change this, for the time being at least. But they do have the power to do it in the future. And another important one is the local authority's right of entry. The Renters' Rights Bill already gives local authorities extensive rights of entry to business premises and in some cases to residential properties, with and without a warrant, if they want to investigate certain breaches, suspected breaches of landlord legislation. And I've done a whole YouTube video and a blog post on this. So the government's amendments relate to the council's power to enter a suspected residential tenancy at any reasonable hour without a warrant if the officer reasonably suspects it's a residential tenancy and they want to investigate whether there's been a breach of the requirement to have an active registration for the landlord and the property on the database, or there's an offence under the Protection from Eviction Act 1977. So that might be a sham licence or just an illegal tenancy where the landlord hasn't registered with the database, or they think that the officer thinks that the information on the database is wrong. There might be fraudulent documentation. The government amendment allows the local authority to enter the premises without giving landlords notice. That's a big deal. So what does this all mean? Well, there are no major changes, no big U-turns, just changes around the edges, which is what we were expecting. And we've got the report stage from the 1st to the 15th of July. And there's no time for the remaining stages. So that's the third reading in the House of Lords and ping pong when it goes backwards and forwards with the House of Commons before the 22nd of July, when the House of Commons breaks for the summer. When will royal assent be? As I've suspected for a while, I think royal assent will be after the summer break, possibly in the 2 weeks before the conference recess starts on the 16th of September. And if not, it'll be after the 13th of October. What about the commencement date? I'm still saying 2026. the government have promised that they'll give the private rented sector adequate time to repair. And that does not mean squeezing it in between October and Christmas. But things can happen really quickly, and you can rely on me to tell you how it is without all the hyperbole. I send out a free weekly newsletter to keep everyone up to date, and you can sign up for it here. Also, please like and subscribe to this channel if you found it useful. See you soon.